Hello everyone, I am Advocate Imdadur Rahman. Welcome to Lodex Assam. Today we are discussing a very important question. If someone signs and gives blank check and later the other person files amount and present it, will the court punish the check giver? Many people believe blank checks are not valid, but the Supreme Court has given a very clear answer. With the help of these slides, we are going to understand this concept. So checks can be broadly falls into two categories. One is endorsement in blank, only the signature is present, and second one is full endorsement, name and details of the payee are written. But the most important provision is section 20 of Negotiable Instruments Act 1881, which deals with incomplete negotiable instrument. So section 20 of the Negotiable Instrument Act says if a person voluntarily sign and deliver a blank check, they are authorized the holder to fill in the remaining details. That means the check is legally valid. The amount filled later will be treated as authorized. The person who signed it is liable. The court clearly says signature itself creates a legal responsibility. So common real life problem. Most disputes arise in loan and financial transaction. People give blank check as security. Later creditor fill higher amount and present it. When the check bounce, they are immediately file a case. The accused then say I did not write the amount, the check was blank. But the law replies if you signed it, you accept the risk. So Supreme Court position in this a blank sign check is enforceable if it is issued in connection with lawful transaction and a legally recoverable debt exists at the time of presentation of the check. Means giving a signed blank check is equal to giving a authority to fill it. When can the accused defend themselves? A person can save themselves only if they can prove the check was misused. No legally enforceable debt exists, means the check was given before the liability is exist. The amount was falsely inflated. The transaction was fraudulent or doubtful. The complainant cannot, if the complainant cannot prove liability, then uh, it can be treated as a invalid is not is invalid check. If evidence is strong, the court may grant the relief. So the final message for this is never casually hand over blank check. Your signature carries legal power. Section 20 clearly makes you responsible. Supreme Court confirmed liability exists in many such cases. So always act wisely in financial transaction. So in my slides I have shared a real life example related to the check bounce cases. So the scenario is that imagine you need a small urgent loan of 10,000 rupees. Then you out of a good gesture or as a gesture of security, the lender asks for a sign check. You sign it but leaves the amount, date and pay name blank, trusting it will only be used for a aged upon amount. If you default, then security is provided. Later on you find that the trust is broken and stakes are raised. A dispute arises over the payment. The holder of the check fills in much larger amount, for example 1 lakh rupees. They also add the current date and their own name as the pay. The check is deposited. So what is the check was returned, the check memo, check was bounced and it is returned with a memo insufficient fund due to the unexpectedly high amount. The check bounces the blank return, citing insufficient fund. This action can be trigger criminal procedure under Section 138 of the NI Act. The central question is that you signed a blank check for a rupees 1 lakh liability, 10,000 liability. Are you now legally responsible for 1 lakhs? So what is the answer? The liability in such cases is not a matter of opinion. It is explicitly defined by the NI Act 1881. Two key sections provide the foundation for the interpretation. One is section 20, one is section 60. Section 20 incoherent stamp instrument and section 16, as I told you, that endorsement in the blank and full. So if it is incoherent stamp instrument, incoherent means incomplete, is one that is signed and delivered but wholly blank or has been left incomplete. So when a person signs and delivers an incomplete negotiable instrument, and they give prima facie authority to holder to complete it. This authority extends to filing in any amount provided it is covered by the stamp value of the instrument. So the person who signed it is then liable for any holder that amount. So in such situation, payee can feel the amount much higher than you gives authority, and you are totally responsible for that. So the rule is that section 20 rests on a genuine signature. If signature on the check is admitted to be yours, as per law, presume you gave holder the authority. So genuine signature is equal to assumed authority. And if there is an exception, suppose the signature is not matching, if the signature is forged or differ from the one on record with blank, the instrument is unenforceable. The blank will be returned, it marked signature differ, and the protection for the holders do not apply. So forged signs is equal to no authority. So what Supreme Court says in this situation? So while section 20 provides the legal text, it is real world application has been repeatedly tested. The Supreme Court of India has provided definitive clarity through the landmark ruling setting the debate on the liability of the signed of a blank check. So number one landmark ruling, you can note it, the Kalamani Tex precedent. So the Kalamani Tex and another versus P. Balasubramanian 2021 5 SCC 283. The court finds that the Supreme Court held that once the signature on the check is admitted by the accused, the presumption of liability under Negotiable Instruments Act is established. The burden of proof is shifted. It is not for the person holding the check to prove they were authorized to fill the amount. It is for the person who signed the check to prove they are wrong. So there is another landmark judgment, which is Veer Singh versus Mukesh Kumar 2019 for SCC 197. The court held that this case reiterated the principle Supreme Court stated that if a signed blank check voluntarily handed over, the person who signed it is responsible for the amount endorsed it. So court give primacy to the act of signing and delivering the check. The specific of who fill in other details like the amount or date become secondary. So your signature is your bond. Once you sign a blank check and hand it to the someone, you are liable for the amount they fill in. Law shall presume you have given the holder authority to complete the instrument. The defense that the body of the check was filled in by the someone else, not a valid defense in the court. What is the resolution? So revisiting the scenario that you give 10,000, you took loan 10,000 rupees, and as a security gesture you gave the blank check with the sign. So based on the precedents set by the Supreme Court, they are legally liable for the 1 lakh amount. Fill in the check. Thus, their signature gave the lender presumed authority to enter the amount. So what is the final takeaway? A blank check is an act of absolute trust. The core message is signing and delivering blank check is not casual act of security. It is legally equivalent to handling over a signed open-ended financial instrument. The law prioritizes the integrity of the Negotiable Instrument Act to ensure the stability of the commerce. Exercise extreme caution, the law will hold you to commitment your signature represent. So that's all for today. Thank you very much. Please like the channel video if you find this video helpful, and please do subscribe. Thank you very much.